note that where legal reforms have had their most practical and efficient impact, they have been led by the bar. And in that case, I will say that the endorsement of this topic at this year's bar conference is one that is commendable. Permit me to start by stating that even though the country has made very serious strides in bringing legal services to the doorstep of the individual, the current practice as far as legal service delivery in Ghana is concerned has some deficiencies that call for some rethinking into the existing practices and also some strategies in terms of expanding the scope of legal services delivery. Here we'll look at the overwhelming legal needs that we have in the country that keep arising for a number of reasons, because people are getting to know of their rights, people are becoming more assertive of their rights, but the avenue to have these rights vindicated is not always available because of the number of lawyers available to provide legal services. This has also resulted in a status that we have the unattained promise of access to justice for all persons in the country. And generally it's because we have relied solely on lawyers as legal services providers in this country. There is a need, therefore, to have a comprehensive agenda as far as access to legal services is concerned in this country. And therefore, we will have to look at options available. The situation in which Ghana finds itself is not peculiar to the country. All common law countries have the same situation, but other countries have taken the step to recognize paraprofessionals in law, which we call paralegals in this setting. Ghana has not done that yet, and I think that is an opportunity for us to look at that option of adopting paralegalism in this country for the purpose of expanding the scope of legal services delivery. The aim, therefore, of this presentation is to present a perspective into promoting the growth of the legal profession in Ghana by expanding the scope of legal services delivery, those who can deliver legal services in this country. So this is going to be the focus of our discussion. But then again, before delving into the core of paralegalism, let me present here some underlying realities of our legal system that will inform the need to have reference to paralegal practice in Ghana. We have high demand of legal services in this country, and as I stated in the introduction, it's because people are becoming more assertive, people are becoming more aware of their rights. We have institutional needs also. Now, for all those who are in the law faculties, we realize that we have many professionals who are coming to read law because they think that they need to have some legal knowledge to be able to perform some services in some state institutions and also private institutions. In addition to the high demand of legal services, we have the high cost of legal services in the country that basically curtails access to justice to a number of people in the country, which situation is also compounded by the overwhelmed legal system that we have in the country. In addition to the high cost of legal services, we have limited access to legal services in the country. As was presented yesterday, the country can now boast of 3,800 lawyers who are in good standing to serve the entire population. And in addition to limited access to legal services, one key thing is the unequal geographical distribution, which makes access to legal services in some part of the country problematic because lawyers are just not available. Or even if they are available, of course, they are not accessible because of the monies that some people have to pay. And one key issue here to look at is what I would call the legal exceptionalism, and that's the fact that per our legal practice, only lawyers qualified to deliver legal services, and that is a key problem. Once we do not think outside of the box to look at how other professionals can come to assist in delivering legal services, then we will create some kind of artificial problem, thinking that only lawyers can resolve all forms of legal problems. But we must understand that there are some legal services that do not require the services of a lawyer, or that do not require a license to have them resolved. And in that case, we'll have to look elsewhere and then think about some other options. We have an overburdened court system, and these days we have the alternative dispute resolution mechanisms that have been attached to our court practices. We realize that these are people who are all trying to come in to help alleviate the weight that we have on our legal service delivery, but some of them are not lawyers, because these are people who are experts in alternative dispute resolution mechanisms, but not necessarily lawyers. And these are people that, of course, will have to think about training, in terms of getting some legal knowledge in the performance of their duties. And again, because we do not have lawyers to attend to all the legal needs, we have a rising system of self-help. And here I mean self-representation, where people desire to go to court even though they do not have any legal knowledge, and then trying to assert their rights in the best possible way they can, which we know is problematic in a system that is adversarial like ours. Of course, we have individuals who have even approached the Supreme Court trying to seek some relief in terms of making available some specific, or let's say unique procedural rules for persons who are not lawyers, but who desire to represent themselves. And all these things point to the difficulties, the issues, the problems we have in the legal system. In other words, the fact that access to legal services is limited, and the fact that access to justice is also limited. Therefore, in other countries, as I stated, there is recourse to paralegalism, because it is a system that seems to bring some kind of relief. And it is actually seen to be one of the most reliable ways of alleviating the weight that it is on the system in terms of provision of legal services. Very reliable, many countries have adopted it. And it is also an intervention to break this idea of legal exceptionalism. In other words, thinking that only lawyers can provide all forms of legal services to people. And we have seen in America since the 1960s, and in the United Kingdom since the 1980s, we have very solid paralegal practices that have developed in these countries. Many countries today have followed suit, and we think that is a time for Ghana to also consider the idea of introducing paralegals in the country. Who in that case will be a paralegal? Here we refer to a person who is qualified that through education, training, or work experience to provide some amount of legal service. And here by legal service, we are not talking about giving legal advice that falls within the remit of lawyers, persons called to the bar, or legal representation that falls within the remit of legal practice by lawyers. We're looking at legal assistance, some form of legal advice, but that will not require, something, in the core legalities as we say it, but basic information that can be given to people, basic assistance that can be given to people outside of the courtroom. These are the works that paralegals can offer. The international law, even though on soft law, here has recognized the need to have paralegals in the legal systems. So in many countries, we have steps taken to ratify and domesticate some of these international instruments. Here I can refer to the African Commission resolution on the right to fair trial and legal aid, passed in 1999, adopted in 1999. We have the African Commission principles and guidelines on the right to a fair trial and legal assistance in Africa, 2003. We have the United Nations Legal Framework of Paralegals in Legal Aid, 2012. We have the Kampala Declaration on Community Paralegals, 2012. We have the Lilongwe Declaration on Accessing Legal Aid in the Criminal Justice System in Africa, 2004. These are all international instruments basically recommending to states the need to adopt paralegal practice to assist lawyers in the delivery of legal services in the country. And therefore, these instruments, even though they are basically within the criminal justice system, have interpreted to also apply as far as civil matters are concerned. So in criminal justice system, for example, a lot of recommendations have been made that to help lawyers in the delivery of legal services in the criminal justice system, there's the need to have paralegals to assist accused persons at police stations, in the court, in the prisons. So all these instruments are there. Basically, I think that it's hard time Ghana also took the step to, follow suit, look at what other countries have done, and also think about how we can incorporate the practice of paralegalism in this country. Now, as far as Ghana is concerned, our framework does not prohibit paralegals, even though for now, the only body that is recognized to give legal services or to deliver legal services, lawyers. But we think that since there's no express prohibition that we cannot have paralegals in the country, then it means that there is a possibility of also adopting in the country the practice of paralegals. This is an opportunity for us to develop alongside the legal profession another group of legal practitioners. I put legal practitioners here in quote, persons who deliver some amount of forms of legal services, definitely to help people who may not have access to lawyers. But of course, these are paralegals who will not get into the field of the core activities of lawyers. The opportunity here will be to provide high quality legal services at low cost to some people. And also for us to also recognize that there are some legal tasks that do not require lawyers to solve. There are some that will definitely require the services of a person who do not qualify as a lawyer, but qualified to provide basic assistance to such persons and who have to formalize that practice. And this is not something new. We shouldn't think that in Ghana we do not have any paralegal practice going on. We have some existing paralegal practices in the country, even though they appear quite informal. Law firms are using paralegals these days. And of course, it is something that is implied to recognize under etiquette rules. When you look at rules 46 and 47 of LI 2423, they talk about persons who are assisting lawyers in the delivery of legal services in their chambers. So to the extent that we employ these people to help us in our law firm, they are not lawyers. These are some informal paralegal practice going on. We have civil society organizations and non-governmental organizations that are into a very robust form of paralegal practice in this country, especially in the criminal justice system and also in some civil matters. We have the presence of these organizations trying to provide some form of legal assistance to people who are completely deprived, people in the communities, assisting accused persons in the police stations, some in the prisons, running all sorts of programs. So these are people who have not been recognized as paralegals, but the work that they do in terms of the provision of these legal services that do not in any way interfere with the lawyer's practice. Of course, this is something that we have to recognize at this time. In terms of the legal aid provision, I think that it is one core area in this country that has gained root. The state institution has recruited people. They are not trained as paralegals per se, but they are delivering paralegal services. They are not lawyers, but they are assisting persons who need basic legal assistance, both in civil matters and criminal matters. And we have even the Legal Aid Commission Act itself, which under its section 32G and then 21E, recommends the introduction of a paralegal practice in this country to help in the delivery of legal aid services. So we think that looking at all these things, we think that it is a practice that is not formally recognized, but somehow grounded in a lot of practices. Some intriguing practices are also to be noted. And one thing that we have to take cognizance of is the fact that even these days we have people who are not lawyers, but are appearing before administrative bodies, quasi-judicial bodies to represent people. They are not lawyers. One case in point here is the National Labour Commission, where we have people who are, either consultant or in some other capacities, but have clients that they represent before the commission, sometimes against even lawyers. Of course, they are using the knowledge of the labor law, try to vindicate some rights of employees or employees as the case may be. So this is something that we have to recognize. And then we also have people in this case, in these modern times in our courts who are practicing And here they're not practicing as lawyers, but are people who take power of attorneys on behalf of others. And then they make representation in court, acting under the power of attorney to prosecute cases of people. They are not lawyers, but this is one, I think, way that is not catered for in rules, and that others are also taking advantage of. They can take powers of attorney and then represent the person and prosecute cases. Some even do it up to the Supreme Court. So this is a form of a paralegal practice. This is not a lawyer, but he is acting, in this case, providing basic legal services, and sometimes even beyond that, to infiltrate the court system and then having proper adjudication done on behalf of people who are clients. And also, one general thing that we have to look at is what I call the guru practice that we see all over the place in state institutions, the guru practice, the middleman practice. These are people who are there basically acting to provide some form of assistance, sometimes non-legal assistance, but facilitating processes. It is an illegal practice, but if we recognize that in some cases, these people are there to provide some facilitation, and it is not something that can be eradicated completely, then I think we may have to think about formalizing it. Why don't you then train these people such that they can provide basic, legal assistance to people? For example, for those who want to register land titles, or want to conduct some searches, or want to, basically acquire some basic legal services, and then we have these middlemen. Is it not possible, for example, to then train them if the system is unable to eliminate them? Train them properly and then let them qualify as paralegals so that they can deliver some of these services. Looking at all these instances of practices that I have exposed, and then also the fact that they are firmly rooted, one thing that we need to know is that they are not regulated. They are not regulated, because whether they're in law firms, whether they are working with NGOs, we do not have any standardized educational requirement in terms of who qualifies as a paralegal. Therefore, we've had people setting up their own institutions, trying to train paralegals, and therefore there's no uniformity. So we need to start thinking about it. If it is a practice that must be recognized, then let's think about having in place some form of standardized educational requirement, a system of accreditation, a system of licensing, to get them to be properly formalized so that they can form part of legal services providers in the country. And of course, we don't have any formal structure for now. There's no specific regulatory framework. There's no definition of who a paralegal is. Of course, so many types of paralegals across jurisdictions, so many of them, and it's up to each state to determine, the form and then the nature of paralegalism that you want to apply. So this is some of the things that Ghana will have to look at for the purpose of giving our paralegal practice some form of recognition. So in terms of, putting in place this structure, we have to think about regularization. And regularization here, we mean just like we have set the professional system for lawyers, we need to have one also set separately for paralegals. So there's therefore the need to have a system to give full recognition to the paralegal practice in this country, full recognition to the paralegal practice, especially through legislation, and then through the recognition to also give them some legitimacy. By then, once we have given that recognition and legitimacy to the paralegal practice, I think that a number of benefits are going to flow therefrom. We are going to set some minimum standards to establish the competence and then professionalism of these people so that they can be properly integrated into the system. There will be a need to set their operational framework properly so that they can also be supervised in the delivery of whatever services they need to give to people, generally to protect the public. In terms of attaining recognition, paralegalism attaining recognition in this country, we think that the main problem lies with the bar. And it may not be a problem, that is if the bar recognizes that there's a need for a paralegal system in this country. And therefore, we need to try to draw the dichotomy between what legal practice is going to be as far as lawyers are concerned, and what should also be a paralegal practice for persons who are not lawyers. Once we draw that distinction, there shouldn't be any problem, because the main issue as far as the introduction of paralegal practice is concerned in all countries is the resistance from the bar. But where we are able to draw the line between the activities of lawyers, the remit of the legal profession, and then paralegal practice, we should not have any problems at all having paralegals as a system properly formalized to assist lawyers in delivering legal services. In that case, there will be the need for some amendment also to some of our provisions in the Legal Profession Act and also the regulations accompanying it, because we need to redefine what the practice of law is concerned. For now, legally, the practice of law is in the hands of lawyers only, but we need to expand that definition of the practice of law to also include practice by paralegals, so that that sector, the scope of the activities of paralegals should also be properly determined, so that we can have that clear definition of what the practice of the law is, what would be the scope of activities of paralegals, as against what is the remit of lawyers' practice. Again, we may have to look at what unauthorized practice of the law is. The current situation, again, is that only lawyers can provide it, and therefore we have even a criminalization of act of providing legal services by persons who are not lawyers. If we think that there will be the need here to adopt paralegalism as a system to complement delivery of legal services by lawyers, then there will be the need to also look at that concept of unauthorized practice of the law, so that we arrive at a situation where recognition is given to paralegals and the criminalization is also reviewed. The practice should be properly regulated. Therefore, we need to have a system of accreditation. We need to have a system of proper training, licensing, and certification of paralegals. The instances of paralegal practices that are introduced in terms of the civil society organizations and law firms and all, there's no regulation. So for now, how they are treated, the safeguards against abuses do not exist. And because these are people who are going to deal with the public, we will need to be very careful about how to couch a system of paralegalism that will not expose the general public to people who are likely to abuse them. Again, we'll have to define what we will call paralegals in this country. Are we looking at people who are going to just assist lawyers directly, like in law firms, or we need people who will be exposed directly to the general public so that they can offer basic legal services, but of course, that are clearly defined in a set of laws. So this is something that you have to look at, but definitely irrespective of the mode of paralegalism that we choose, whether a regulated system or independent paralegals or paralegals assisting lawyers, there must be a need for a system of accreditation, training, licensing, and certification. For now, we have the General Legal Council that is in charge of legal education in the country. Of course, under Act 32, Sections 1 and 13, they're in charge of legal education in this country. Therefore, in terms of organizing these accreditation programs in the training, licensing, and certification, the body is apt and equipped to basically deal with this, introducing or setting up all the mechanisms that will be needed to have a strong paralegal practice in this country. Defining the paralegal activities in the country will also be very important. One thing, of course, as I stated, is to avoid a clash between what a paralegal does and then what a lawyer also does. And for that, we can already hint at giving some indicators here. Everything that requires legal advice, everything that requires legal representation should go directly within the remit of the legal practitioner. But all other things, in terms of providing legal education or basic legal information, is something that the legal profession or the bar today should be ready to share with paralegals, because these are not matters involving litigation, and then we are not also talking about giving paralegals that right to advise persons in terms of issues that can end up in litigation. Not at all. That will not, the remit of paralegalism will not get to that level. Theirs will be to just provide very basic legal information, assistance, and maybe I was talking about the scope of paralegal activities that will have to be clearly designed so that we get to avoid any potential conflict between practice by lawyers and practice by paralegals. We're looking at developing a code of ethics for paralegals because you're dealing with the general public and because they're going to represent the interest of people. Then, of course, they must have some commitment to ensuring that they also abide by some rules of conduct and etiquette. There is one core issue, however, that we have to look at critically, and what I refer to as the legislative restrictions that we are putting on who qualifies sometimes to do what. I give the example of the Real Estate Act, where we basically talk about who can provide some type of services. Either the person is a lawyer who has to take some other course and this person wants to take some other course. These legislative restrictions do not accommodate paralegals. And that's something that we have to look at, because so far the legislations that have been passed that determine who can provide some type of legal services or some type of services, no consideration was given to paralegals. But if you are looking at paralegals in that broad framework, where we're looking at people who can provide some legal assistance, then in respect of activities, in respect of the nature of some works that require that the person has some basic legal knowledge, we will have to think about incorporating paralegals in there, because once the person has undertaken some course and qualifies as a paralegal, that person, for example, should be in a position to provide services in the real estate market, for example. But of course, the new act does not mention paralegals. We have to look at it, and the General Legal Counsel, in trying to design the course for training of these paralegals, will have to harmonize the licensing regime with the licensing that exists under some of these legislations to avoid a system of multiplicity of licensing, so that while we have just one unit, the person can train either as a paralegal or train under some other institution. They should all qualify to provide services, provided they've taken the course related to that particular work or field. A number of benefits are expected to be won through paralegalism. First of all, if you have a vibrant bar, as we have it, which is assisted by a paralegal system, and I think that will have done a lot of good to the people of this country who require legal services. Of course, for those who have the means and can approach the bar and then get the legal services, will do so. The rest that are unable to have the assistance of lawyers can also approach paralegals, especially if the matter that the assistance they need is not one that is falls within litigation and other things, other areas of practice of lawyers. But for basic assistance and all that ordinarily you have to go to a lawyer. Of course, if a paralegal can provide that same service at a cheaper price, that should be available to the general public to make that choice. Again, we have a career path that is gradually building up. If we also recognize that paralegalism can be considered as a profession, for the thousands of people who are now reading law, the thousands of them who are unable to make it to the law school, and for that matter will never qualify to be lawyers, this will be an avenue for them to find, work to do. I mean, they can be professionals in this area if it's about providing some basic services, and they can basically carve a niche in there, develop a profession in there. I think that is a good cause for us to look at. That will also take the pressure from the General Legal Counsel in trying to find a way to accommodate the thousands of people that we have. we can recognize paralegalism and we can make it a serious and vibrant profession for the thousands of people who are also looking at, practicing, not becoming lawyers, but operating or professing in the field of law. We can look at that. Affordability, that's one advantage I have mentioned. Of course, not just affordability for the ordinary person, but even for lawyers. We think that for law practice, if you have a system of paralegalism in there, it will definitely affect the way our billing system is done. It will help us get more clients. It will also help the client reduce his bills, because for some things that a paralegal can do, of course, the billing system will be different from what a lawyer does, especially in terms of research and other things that paralegals do in the law firm. So we can look at that. That is one opportunity for economic value to law firms, and then we can look at exploring that. For state institutions and agencies that are unable to have lawyers sitting in the law firm in those institutions, I think that getting paralegals in some of these state institutions will also help to enhance the delivery of this delivery of public services in these institutions. For local government agencies or state agencies, private agencies that deal with the law and that do not require necessarily the presence of a lawyer in those institutions, I think that trying to make available paralegals, train paralegals and put them there so that at least they know what they are required to do. They know how to enforce the laws in those institutions. They know how to provide efficient services. I think that that's something that will be worth exploring, something that will be worth pursuing in there. Because as I said, in the law faculties these days, we have hundreds of these people coming in every day trying to apply to read law. And the main reason why they want to read law is because they think that in their positions, in their offices, they are working with some legal documents that they do not appreciate very well, and that they do not have the opportunity to hire the services of lawyers because they don't have the capacity to do so. But if they had some basic knowledge of it, or if there was somebody sitting there in the office who had some basic knowledge, working knowledge of the legal documents or the legal framework that applies to their field, they will have delivered better services. In this case, it means that talking about paralegals, we are not looking at the interests of just individuals. We are not looking at just law firms. We are not looking at civil societies alone, but even state institutions. We can have people trained as paralegals who will help in making efficient the system of providing services in public institutions, private institutions, especially as far as they have to deal with the law. I'll conclude here by saying that we have come a long way as a country. We have done what we can using lawyers to provide legal services, but more can be done. There is an opportunity for us to expand the scope of legal service providers. There is an opportunity to grow our legal service system in this country by not only looking at the interests of lawyers, but also supporting the work of lawyers by developing a strong, vibrant paralegal practice, one that is regulated, one that is well-defined, one that will have that legitimacy to provide the needed legal assistance to lawyers so that we can provide for the needs of the thousands of people in this country who do not have access to lawyers, who do not have access to legal services. Once we adopt that motion of having the legal practice introduced into the Ghanaian legal system, our records as a state catering for the legal needs of its people, as a state defending the rights of its people, as a state guiding the core values of rights and access to justice will be high. Therefore, I make this urgent appeal at this bar conference for all of us to think about this opportunity to endorse the paralegal practice in this country, to also put us in alignment with some international obligations as far as providing for the legal aid needs of our people is concerned. I thank you very much.
Hello.
Hello.
Despite the technological challenges, I hope we have been able to hear something. We will thank Dr. Isidore Tufuor for the delivery. and take any questions, if any.
Thank you very much, Mr. Moderator, and thanks, Dr. Tufuor, for the presentation.
Thank you.
Mine isn't a question, it is a contribution, and I will make it brief. I will start off with a caution. And the caution is, we should, of course, endeavor to avoid resisting a reality. But we should also avoid opening a Pandora's box. And therefore, how do we endeavor to do both? The sister professions have tried to accommodate related institutions in a way that can guide us. Architects have draftspersons, accountants have accounting technicians. Fairly recently, physicians and surgeons have allowed physician assistants and the like. But it is not under any dispensational regime for a parallel or even a competing profession. They are all regulated under authority. And if we are therefore looking at such a regime to our country at this time, we should perhaps avoid a situation where we will be opening floodgates to anyone pretending under the guise of paralegal practice and actually doing legal practice. And that is why I say there's a certain caution. For this reason, it's always been fairly well understood that conveyances and those in limited appearances before administrative tribunals can put in an appearance. So we may wish to limit it to these two. But as for sound paralegal education and its regulation, no one can dispute that. But it should be essentially to equip those who will be designated as law clerks and legal secretaries and those assisting in the registry of our courts to do their work well. Because we need that capacity built for our law chambers, our law departments, and our law courts. So if we identify the target audience, such as what we have said, then we will roll out appropriate training for them. But it is not opening it up for everybody. And then in limited disciplines, as I suggested, conveyances and the like, we can also do that. But as has happened in the education space, even though pursuant to decision of the Supreme Court, the field has been opened up, anyone can establish a private university or university college, but they are required for a certain period to be under mentorship. And so if we are even doing such a paralegal practice, it will be my suggestion that they be associated or affiliated to law chambers. If we don't do it this way, there will be difficulty. So I will conclude on the basis that it is perhaps something to embrace, but a good idea is not necessarily opening the floodgates. And we should put in place appropriate limitations so that quality assurance will be done. In the legal field and in the judicial space, there were magistrates at some point in time, lay magistrates, career magistrates, and the like. But they are mainstreamed. They are not left as parallel professions. And I think with these serious limitations, your comments and suggestions are well noted. Thank you very much.
Thank you.
Any more questions?
As Prof has eloquently contributed, Doc, my question to you will be, from the jurisdictions that you have studied and how they implement the paralegal system, what will be the typical limitations beyond, say, looking at limiting them to, say, district courts? What will be the typical limitations that you find in the other jurisdictions. I'm sure that we'll all come to the conclusion that there's a lot of work and we are not available to do the work, particularly when you look at the hinterland.
Yes.
We are here in Bogatanga and we were, told of the statistics. All the five regions have 39 lawyers. Here in Bolga, with a region with 1.3 million, you have only 14 lawyers in active practice here. So clearly, there is a need that we are unable to meet. What should be the limitations, looking at the typical situations in the jurisdictions that you have studied? Thank you.
Good. So we do not have a uniform paralegal practice across jurisdictions. So apart from, I think, 1 or 2 states in the United States and Ontario in Canada, where lawyers and paralegals are allowed to access district courts, in all other jurisdictions, the question that I was answering, I was saying that ordinarily we have for the majority of jurisdictions, you do not have paralegals going to the extent of assisting in court. So paralegal assistance is always out of court or providing some assistance to the person who will be in court. So in terms of making up for the number of lawyers that we need in the country, I do not think that we can resolve that using paralegals. That's going to be my submission on it. All right, thank you very much.
The presentation will be uploaded. All right, so thank you for